Good morning to all of you. అందరికీ శుభోదయం. Welcome to Legal Matters by Sai Babu Sukar. This is an important video as far as people giving general power of attorney from America or from other country is concerned. Friends, you have to remember that even though you are going to give a GPA in favor of somebody in India, this country, this state must be a reciprocating country as per section 14 of the Notaries Act. How do you know that it is a reciprocating country or not? I will tell you later in this video. Justice K. Babu, this is Kerala High Court, Justice K. Babu, in the case of Margret alias Thankan, THANKAM versus Joseph Mathew chettupuzha, CHETTUPUZHA. This is an OP civil number 3213 by 2018. On 31/7/2025, held that the power of attorney executed in foreign country will be admissible in evidence only if it is proved that it is a reciprocating country. Right? So, every GPA executed before the Notary Public in America or England or other place, it will not be accepted unless it is proved to be a reciprocating country. Now, how you will decide whether it is a reciprocating country or not? Every year, the government of India will be giving a gazette notification as to which are the reciprocal countries. If you see the gazette, definitely it will be there. Nowadays, online gazettes also have come. By that, you can understand that it is a reciprocating country. Second, you have to request the Ministry of External Affairs to get a copy of the same. Then only this will be valid. For example, if you execute a GPA in Pakistan, it will not be valid in India. If it is in America, it will be valid. But here the dispute is regarding the Missourie state. We'll come to that part later. So this is an OS, original suit number 179/18, filed by the so-called Margret alias Thankan. Actually, this Margret alias Thankan may be a lady, I don't know whether she is a lady or male, staying in Missourie, USA. Missourie state, St. Louis అని మీరు పెద్ద ఆర్చి కనపడుతుంది, అది మిజోరీ స్టేట్లో. రైట్. సో he gave GPA to somebody and it was executed by the Notary Public in so-called the state, Missourie. Right? He filed OS, the GPA holder, he filed original suit for actually this is a family dispute, release of certain property and acceptance of gift deed, other things. There are so many details we need not bother about the same because the case is regarding GPA holder. రైట్. సో ఇక్కడ ఏమైందంటే ఇతను తీసాడు, ఓఎస్ నెంబర్ వేసాడు, ది సబ్ జడ్జ్ ఎర్నాకుళం సబ్ కోర్ట్, ఎర్నాకుళం సబ్ జడ్జ్, సిన్స్ ఇట్ ఈస్ notarized in USA, he has accepted the same. But this was objected to by the so-called other party. They filed application under Order 6, Rule 16 and also Order 7, Rule 11, arguing that this particular GPA is not valid for recognition in India. Why? Because Mr. Mathew says the state of Missourie is not a reciprocating one to India under Indian law. Second point, without proper stamps under Kerala Stamps Act, this was filed, which is not correct. Even though it is notarized there. While filing the case, you have to affix the regular stamps. But they were not affixed. Therefore, it is violation of Kerala Stamps Act. Therefore, the documents failed to comply with the Indian laws. ఒకసారి సెక్షన్ 14 చూస్తే reciprocating country. The GPA executed in a non-reciprocating country is not valid, could not enjoy the presumption that it has been executed. Alage, unless it is presumed to be correct, then section 85 Indian Evidence Act kuda raadu. This is presumption of execution of the GPA. So defense lawyer, sir, we thought that it is reciprocating country, even though it is not a reciprocating country, since it is valid evidence, OS ఉంది కదా, 67 of Evidence Act కింద తీసుకోమన్నారు. సో అది కూడా మనకు వద్దు, మెయిన్ సెక్షన్ 14 మీదే హైకోర్టు బేస్ అయింది. బికాస్ the presumption under section 14 of the Notary Public Act 1951 అనుకుంటాను, 1952 అలాగే Indian Evidence Act section 35, no presumption can be drawn without the central government notification regarding a reciprocating country. అందుకే మీకు చెప్పాను, central government every year they will declare through gazette notification. So this was stated in the case of Jugraj Singh versus Jaswant Singh 1970. అలాగే కేరళ స్టాంప్ యాక్ట్ డాక్యుమెంట్ ఫెయిల్డ్ అన్నారే, దానికి Re-Agro Limited and Indira R. Pillai versus Federal Bank Limited 2015. These two are the renowned cases. You can go through the case laws. Now, the decision of the judgment. Upon detailed analysis of section 14 of the Notary Public Act 1952 and Indian Evidence Act section 85, they cannot be read in isolation. You have to read them conjointly. Section 14 ఒకటే కాదు, 85 కూడా రెండు కలిపి చదువుకోవాలి. The interplay between section 14 and section 85 cannot be read in isolation. As for section 14, it is definitely essential to be notified as a reciprocating country. In the absence of proof of reciprocation, the entire thing will be a futile exercise. The trial court is not correct. I think the trial court has committed an error. But anyway, the OS did not stop here. The High Court has given a leverage to the plaintiff to produce evidence that Missourie is a reciprocatory state, and then the case can be continued. So matter is once again coming to the ball of the plaintiff to prove that it is a reciprocal country. So what you have to learn is, the Indian courts will accept the GPA if it is a reciprocating country. If not accepted. Next section 14-15 of the CPC చెప్పినప్పుడు how the foreign judgment will be allowed అనేది కూడా చెప్పాము. అలాగే ఇది కూడా వెరీ ఇంపార్టెంట్ కేసులో, పర్టికులర్లీ for the people who execute the GPA in favor of their relatives in India. They have to attest it, they have to prove the state is a reciprocating country. I think you might have understood well. I am stopping here. Read the case law, Kerala High Court judgment, and enrich your legal knowledge. Thank you.